Well, would the broadcast of the trial have been any different from what you've just seen? I submit the best evidence is an actual clip of the trial. What I'm going to show you is David Boyce's cross-examination of the proponent's political science expert, a professor, Kenneth Miller, at Claremont McKenna Colleges. The issue is whether a ban on permitting same-sex couples to marry fits the professor's definition of official or state-sanctioned discrimination.
That's what you refer to as official discrimination.
And it's legally enforced rules that have an effect on gays and lesbians, which is different than heterosexual people, yes.
That's what you refer to as official discrimination? Is that true? I'm just trying to get your word.
Yeah, well, I'm maybe legal is a better word. It's or de jure. I don't know how you want to describe it. Various different ways to say the same thing.
What word is the word you use? Because I just want to use your language.
Okay, official would be fine.
Official, okay. And by official discrimination, you mean discrimination that is legally enforced, discrimination by the state, correct?
I think that's fair to say, yeah.
Now, are you aware of any of what you call official discrimination against gays and lesbians in this country today, other than the don't ask, don't tell policy?
No, I'm trying to think of other laws now, or official policies that discriminate on that basis. Now, obviously, I think what you're looking at is, one thing would be the DOMA policy, right? And
there you go.
Okay, so I know that's what you're getting at, right?
Right. That'd be another example. Yes.
Okay.
If you're looking at adoption, some states treat heterosexuals differently than homosexuals, correct?
It's a more complicated area of law. I think there's more discretion by individual judges. I think that only a couple of states have statewide policies that actually restrict adoption. Now, Arkansas is an example where the restriction is on unmarried couples. So that could be either heterosexual or same-sex.
Yes, but in Arkansas, they put that in at the same time that they put in a law that said that gays and lesbians couldn't marry, correct?
Yeah, but that's correct. But also,
so it means that because gays and lesbians can't marry, by definition, they're not going to be a married person, so they can't adopt, correct?
That effect is correct, but it also applies to heterosexual couples as well.
Except heterosexual couples can marry, correct?
They can
in
marry.
Arkansas.
Yeah, but it is a restriction on them that they would have to marry in order to adopt.
Right. And gays and lesbians can't marry, so they can't adopt, correct?
That's the current law.
Well, I think that makes the point. All of us who have been trial judges or trial lawyers know that in a trial there are those long periods of silence that occur. There's undoubtedly lots of tedium in trials. One of my colleagues, Lowell Jensen, has a remedy for this problem. He takes a sharp pencil, he puts it on the bench, he takes his finger, puts it on the eraser end of the pencil, puts the heel of the palm of his hand on the bench, and when the testimony gets just a little too tedious and he begins to goes off, his hand goes limp, the pencil begins to fall over, and he wakes up. The public ought to see that in any trial there are those moments when not much happens. And the other interesting point is the train of examination of a witness that occurs only in a trial court really doesn't occur even in an appellate court, where the argument is between a judge and a lawyer, oftentimes, as was pointed out in the panel this morning, on issues that are legal in nature and which float above the ken of most people. But that's much less true in a trial court, where you can see a train of argument, a train of thinking, a train of logic follows inexorably. And so, if anything, of course, I disclose my bias here, I think a broadcast of a trial would be even more interesting than the broadcast of an appellate proceeding.